Hello, good evening, good afternoon, everyone. My name is Professor Rodrigo Olivares Caminal, and I am delighted to welcome you today. If you don't mind, I will wait 30 seconds, 1 minute until people start coming in. I think that basically there are already 30 and going up, so we should start in the next few seconds.
I have a question to begin with. I always thought it was caminal, not caminal. Is that right?
In Spanish, it's caminal,
Right.
But I don't know why. Probably in English, I give it an English accent. So, good afternoon, everyone. Welcome to the third webinar of the series that Universidad Complutense de Madrid and Queen Mary University of London are organizing on issues related to insolvency law. It is a pleasure to welcome you today to our third seminar, which will be discussing legislative reforms and new trends in insolvency law. It is a pleasure to welcome a team of rock stars who will be joining me today. I am welcoming you on my behalf and Juana Pulgar's behalf. Professor Pulgar, unfortunately, had to travel today because of a business matter, and she will not be able to join us today, although she is commuting, so she might be able to join briefly at some point. But I wanted to extend her apology for not being able to welcome you all today. Having said that, I'm going to introduce our speakers today. They don't need introduction, and due to time constraints, I'm going to be very brief in the introduction, but we have Catherine Bridge. She works at the EBRD, and she is responsible for insolvency law reform. We also have Andres Martinez from the World Bank Group, who also deals with insolvency law reform at the World Bank. We are also joined by Professor Christoph Paulus, who at the moment works in insolvency matters as of counsel with White & Case in Germany and with South Square in London. And we also have Ignacio Tirado. Ignacio, I don't know if I should refer to you as a professor or not, but Ignacio at the moment is the Secretary General at UNIDROIT. I think that you still hold the honorary title of professor, I guess. So it is
not honorary. It's for life, you know. When yeah. You're a civil servant in Spain, you have that sense.
So I would like to extend a warm welcome to all of you. And as I explain in each of these webinars, the idea is to have an open, frank, and informal discussion about the issues that we work on, that we research on, and we write about. And the idea is to have a dynamic, relaxed conversation among a group of friends, which is what we are. And I know all of you personally. I have worked with most of you, and it will be a true pleasure to have a conversation on what are the new trends. Please, by all means, feel free to talk to each other. You don't need to come through myself, the moderator. And if there's a disagreement, it will become heated, and I think probably even more entertaining. So I will see if we can manage to square divergence, or probably not. But I think that's what I wanted. And for participants, I didn't anticipate to the speakers any questions, and some of them were getting a little bit nervous as the event was approaching, because basically, Rodrigo, what you're going to ask, and say, we're going to have a conversation among friends and colleagues that share a common interest, and that's the idea. So please, let's try to emulate that. And of course, needless to say, due to your current positions, if there's any issue on which you cannot comment, feel free to openly say that, and probably Christoph or myself will try to comment on it if we can. So, Catherine, if I may start with you. With Catherine, we've been recently completing enormous task, which is canvassing 38 insolvency laws in the countries of operations of the EBRD.
40.
Yeah, 40. Yeah, and actually 40 jurisdictions. Yes, yeah, 40 jurisdictions. 38. Yeah. 38 economies, 40 jurisdictions. So, Catherine, I think that basically we collected some data from there, and probably I think that you are in a privileged position to give an opening 1 or 2 minutes of what you see and what are the latest trends in insolvency.
Thank you very much, Rodrigo. I'll try. It's been an enormous task looking at legislation from 40 countries. And as you start to look at it, patterns, of course, begin to emerge. I think what we are seeing now with the EU restructuring directive is a potential gap widening between the countries where EBRD works, which are EU member states, and the countries which are non-EU member states, and which haven't benefited or are not required to follow this new European trend towards preventive restructuring. So I think when we were doing this assessment, that was one of the challenges, is that insolvency laws, as everyone knows, are evolving. They have evolved in response to the financial crisis. They're evolving in response to COVID. And latest trends. I think what's interesting is there are some countries which really have done very little with their insolvency law for some time, and I won't name names, but there are still countries that have not, I would say, embraced the need for a modern insolvency framework. And there are other countries which are really have been working on it for years, but almost at the risk of overcomplicating things. So I think that's something we've also been looking at in our region, that there's a lot of reforms that are undertaken in areas like insolvency, because perhaps there are requirements for international organizations, and sometimes the reforms come too quickly. But generally, we are seeing some move towards preventive restructuring. So I think in about 19 of the economies that we looked at, there were hybrid procedures, so a kind of quick in and out of a formal court insolvency process, and we cover about 11 countries that are EU member states. So that gives you an idea that it's not just happening within the EU member states, it's happening outside, as countries like Kosovo, which had has a model, I think, insolvency law in many ways, have worked closely with organizations like the World Bank. What I think is very challenging for the development of insolvency and reorganization in particular is the lack of practice. So, and that's a big challenge. I mean, how do you really encourage debtors, companies to use the tools that are available, to trust, in some cases, the courts? And I think what's been really interesting about the assessment we've done in the survey is that there is a very low incidence in some countries of use of insolvency proceedings, and in many cases there's not enough transparency around the data on use of insolvency proceedings, especially when it comes to reorganization type proceedings. You can have a wonderful law in the books, as everyone knows, but if you don't have practice and then the kind of practice that enables professionals to develop expertise, to become a recognizable professional body of experts, so in the case of insolvency practitioners, to acquire specialism in the case of judges, then really the risk is that you just don't have the kind of insolvency framework that can respond to the needs of business. So I mean, it's just a few ideas.
Catherine, I think that there's so many things that we can keep on discussing.
Yeah, I thought I would mention a few, but I mean, if I talk about the assessment, there is so much that we have
Catherine, I think that you have highlighted an important aspect, which is the law on the books versus whether that law is used, and then also how that law will be interpreted by the judges. So I think that basically there are kind of possible 3 dimensions, and I'm sure that Andres would like to give us our perspective, but Christoph has raised his hand. I don't know, Christoph, if you want to complement something Catherine says, or...
Yeah, I will. I mean, I'm picking up what you said about the discussion. While Catherine was talking, I immediately had a couple of questions, something around 5 to 10 questions. I confined myself. Nevertheless, you said that you mentioned the directive. I mean, the directive is now when you're working for the together with the Commission, as Nacho and I are doing. It is the past, as a matter of fact. We are now working on something which is destined for the harmonization of insolvency laws. So it's far more outreaching. And in this context, maybe that links to what you said towards the end of your presentation, when you said that there is in a couple of countries too less transparency, or at least too less knowledge among the economic actors about the possibilities. Could that be, or could one of the reasons for that be what we are discussing right now in this expert round, and for which Nacho is the best expert you can think of? We have too little insolvency law for small and micro enterprises. After all, 99%, or is it 90%? But I think it's 99% of the European companies are micro and small enterprises. So what I'm afraid a little bit is that the directive has and will be, in those countries which have not yet transposed it into national law, will be spoiled, and now I'm speaking with the German experience, will be spoiled by lobby work by those who are thinking in terms of this is an instrument that should be used for the big, or at least for the bigger medium-sized companies, because there is something to gain from.
Christoph, I'm very happy that you brought this up, because I'm also a strong supporter of simplified and abbreviated procedures for SMEs and all its variations, small, micro, nano. I'm going to give the word to Ignacio, but for the record, for those of you that do not know who Christoph is referring to as Nacho, Nacho is the short for Ignacio. But Christoph, that's very good, because
no. Sorry.
That conveys the exact tone of what I want with these informal conversations.
Yeah, right.
It's a friendly discussion. Nacho, also known as Ignacio, please.
Thanks. Well, first, I'd like to clarify for those of you who are not acquainted with Spanish from Spain, that nacho might be a Mexican food, but it's not a Spanish food. And in Spain, being called nacho is not funny or disrespectful. So you should feel very, very free to use that, because that's what my friends call me. I actually thought that I would try to agitate a bit the discussion by making a modest proposal and say, you know, after many years of study of insolvency systems and a good number of years of work on legal reform, it has, and I'm going to oversimplify, okay, for the discussion, but it seems to me like there are a number of things we should start considering as a possibility to make things work, especially in countries with some level of development, but not fully, which is to divide those cases which are medium to large, which have repeat players in terms of professionals, which have plenty of sophisticated bank debt. And for those, I think what we need is a very flexible system, very flexible, in which creditors and debtors can try to reach a solution without losing control to the extent possible, not too much in court, because in court you just lose control of things, maybe even without the need of a professional. I'm not saying you don't need one, but if you need one, you know, you look for the right one. And this is where I wanted to tease, is I think in many countries we would solve a lot of problems if we place the burden, or if we place a large part of the decision-making power on the shoulders of sophisticated creditors. And by that I mean basically banks. So you bring banks on the table, and banks are the ones that are going to be best placed, in my opinion, better placed than the debtor, best placed to know which debtor is viable and which one isn't to begin with. If you do that, especially if you have a certain type of security rights in the lending scheme of the debtor, which is not just fixed assets, but it's rather, you know, floating type of security, or also fixed charges, that's all right, to the extent that the bank will be interested in a repeat client in the future. So leave a strong part of the decision on the hands of banks as to whether debtor is rescuable or not. And I think they'll get it wrong sometimes. But of course, with the due rules ensuring no abuse, and there's a lot of regulation and supervision of the banking system that needs to chip in here, I think we can solve a lot of problems. And then we have another system for smaller businesses, which is basically a very quick liquidation. And if we do that, sounds very simple and simplifying, but that is going to solve a lot of problems, I think. Sorry, Ignacio, I oversimplified.
Ignacio, saying that statement was provocative, probably would have been an understatement. Before we get back to Ignacio, Andres, sorry, Catherine, but Andres raised his hand and he hasn't intervened yet. So, Andres, what can you share with us?
I have a couple of reactions. I mean, first of all, thank you for the invitation to both Queen Mary and the Complutense. Second, it is absolutely fantastic to come to a panel like this and have no idea what you're going to be asked. I think that's a very fresh perspective. I enjoy it. And then, having said that, let me react on a couple of things that were said. I mean, I wanted to go back to the first point of the trends that we see. I think there is this is a very important moment after the COVID crisis. No, we have a lot of debt that has been amassed. I think there is a lot of distress in the environment, but when you look at the profession itself, there's not so many large restructurings taking place. No, so I think there was a combination of fiscal stimulus, there was a combination of moratorium, sometimes legal, sometimes bank-driven, a lot of uncertainty in the environment that has made that creditors haven't really made their mind start enforcing or, resorting to insolvency cases. I think that is the first point regarding the trends. I mean, I think a lot of countries reacted quickly after the pandemic, either imposing some sort of moratoriums and so on, and now they are truly thinking more long-term, right? And if you look at, for example, countries like Colombia, like Peru, that they implemented some sort of temporary processes that really didn't have so much take up, like some accelerated, simplified processes, trying to expedite time, etc. No, and they are beginning to think more long term, and I think that's good. With the EU, I couldn't agree more the observations that Catherine said. I mean, not necessarily the EU, but in Europe in general, I think there is a lot of discussion about pre-insolvency proceedings. I think, I mean, I'm conscious that not everybody in the audience is has been following this closely. I don't know to what degree of harmonization this directive will lead. I'm more hopeful, as Christoph was saying, about this new harmonization process that the European Commission is undertaking on very critical topics like avoidance actions and a few others, including MSME insolvency, right? So I wanted to point at hybrid being, I think, overly used, and I'm concerned about that because every time I hear the word hybrid restructuring, I think people mean different things. Some people mean pre-packs, some others are purely out of court workouts, stimulus, and so on. I think if there is one lesson that we have learned from the policy standpoint is that the standard traditional London approach guideline, super soft, that say, okay, banks, you should behave well, whatever, they have not led to many restructurings, frankly. And I think that's, again, that is something that took us, I think, took the legal community a bit of time to absorb. And I think hybrid, perhaps it could be used also for these out-of-court workout approaches, central bank led, but with some sort of structure, intercreditor agreement and so on, of the likes of Ukraine, of the likes of Albania, etc. And then moving on to the last point, I think regarding MSME, I think we are all in agreement, Nacho, about the rights of creditors and so on. I think it's absolutely critical, as Christoph was saying. We're talking about 90+% of companies being small and medium. It's absolutely essential to have a process that deals specifically with this type of companies. Most insolvency laws in the world are designed thinking of large companies, sophisticated, formal, etc. And we're dealing here with informal companies sometimes with lack of information. Asking them for 3 years of audited financial statements will not work, right? Now, how to do that without harming creditors' rights and ensuring that there is flexibility in an abbreviated system is not easy. The World Bank published its revised principles on this topic in April this year, and it took us years and years of discussions. Of course, Nacho has been one of the inspiration sources for us, with not only with a modular approach, but also for many years of working together. And really, I think we've come up with a good series of solutions. The same with UNCITRAL has been discussing this topic, and I think we're pretty much aligned. So I think, broadly speaking, the need for simplified SME processes is a reality world. And I will leave the institutional discussion for later on, because I think that's another topic. The number of legal reforms that have taken place without proper capacity to implement them is something that I think it should be a forward-looking statement. So,
Andres, before I give the floor to Catherine, I would like to strongly stress the last statement to make sure that it doesn't go unnoticed, which is basically a lot of these changes, a lot of this reform with proper instrumentalization, I mean, with proper capacity building and the required support to implement them and to manage to get the stakeholder buy-in could easily end up being a futile effort. So I wanted to just stress that to make sure that doesn't go unnoticed. Catherine, you have your hand up.
Thank you, Rodrigo. Just a few comments and reactions. I fully support the fact that policymakers and legislators should be looking at streamlining the insolvency process as much as possible, and making sure it's efficient. Because what we see in a number of countries where we work is very long periods. Sometimes there's a so-called observation period before the court can reach a decision about whether a business is worth saving. I sometimes wonder when I hear about SME procedures or specific SMEs procedures, if that's more an advanced economy concern, because I think in some economies like Australia or the UK or Singapore, I can see that the tools that are available under the legislation are sophisticated, they're widely used, and that there might be a need to rethink everything when it comes to smaller companies. Certainly some of the discussions that I have with authorities in countries where we work, I mean, we cover a very broad range of countries across 3 continents, but are actually more along the lines of, well, our economy is in fact made up of SMEs. So they're our economy, and our legislation is not particularly geared at large corporations. Perhaps it's more towards the sort of medium-sized company than the smaller or micro end of the scale. But I think really this push for efficiency shouldn't be just limited to SMEs. We should be thinking about it generally. I definitely think with the hybrid this hybrid trend, or which, as Andres said, is worth defining. I mean, when I'm talking about hybrid, I'm mostly meaning pre-packs, so where creditors, majority creditors, come to an agreement with the debtor out of court and go to court for confirmation. I think it's very useful in terms of getting around procedural inefficiencies. There is obviously the concern about the lack of court scrutiny in some cases. And what's interesting is in some emerging economies, legislators don't want to give the court too much scrutiny. I think it's worth also noting with pre-packs that it sort of depends on this workout culture being there. And what I found interesting when we looked at this in the context of the assessment, Rodrigo, is that we asked the question, are reorganization procedures common? And in the countries where we had a majority of respondents saying no, we would have expected to have at least seen perhaps some more movement on workouts, but also in the same countries, they said workouts aren't common. So it does pose a challenge to how we develop these kind of efficient procedures and minimize time within, well, ensure that the market uses what's available, particularly as Andres said, there is a need, and then has the practice and the skills to use them successfully. But I'll just stop there because I want to make sure it's interactive.
Before I give the floor to Christoph, I think that I try to highlight some points to make sure that because the discussion is so rich that I want to make sure there are some aspects that do not get lost. And one of the attendees is a Latin American author who wrote a book called, the title is Simple. And what he does in this book is he says that we need to be able to remove red tape, and I think which is a little bit of where we are moving or going with the new trends on SMEs, which is removing red tape, making things simpler, faster, and he goes even a step further and say basically you need to be able to any administrative process needs to be able to be dealt with the phone. I'm not saying that basically doing a restructuring through the phone, but basically this moves towards the issue I think it's kind of an umbrella topic on all the issues that we are saying, which has to do with digitalization. Christoph, you have your hand up.
Yeah, thank you very much. If you permit me, just in order to enrich the discussion a little bit, and allow me please to come from a completely different angle, and that is what concerns me now for a couple of months. When I see the common denominator in our discussion beyond the SMEs, where we are seem to agree that there should be some liquidation. There is what I observe also in the European development, there is a strong tendency towards shifting the responsibility for rescue on the debtor. And another corollary of this development is we want to avoid insolvency proceedings as such. So we have an early warning system, we have a pre-pack, and which in the best of all cases leads to an insolvency proceeding which is over after 17 hours, as recently in Houston. And we have the preventive restructuring framework. That's all fine, that's all good. The concern that I have in this context is another one. I still assume that the insolvency laws rule and role in the economy, in the national economy, is to clean up the playing field, so to speak. So it's meant to shift those assets which are below best possible productivity to a place where they are fulfilling a better productivity. So if that is the task, I wonder if the debtor is the right person to make this choice. Exactly, Nacho. That's exactly the point. I mean, when you look at Johnson & Johnson, when you look at a couple of recent, very prominent American cases, you immediately say, no, that's not the right person. And it's just coincidence. I was mentioning this recently here in Germany, and nobody knew about Johnson & Johnson and the other cases. But there was a guy who is an expert in labor law, and he told me, irrespective of my concerns, he said that in Germany, it's getting more and more fashionable that the companies are, what he said, carving out those parts of the company or of the group which they determine to go down the road. And they are the ones who are deciding this is to survive and this is not. I mean, that's certainly, this decision by the debtor is certainly not always, to put it very diplomatically, to the best interest of the creditors. So is that what we want? Is that where we are heading to?
Christo, so I think that basically, Nacho, I'm going to give you the floor in just 1 minute, but before I do that, I just want to stress that it seems that Christoph is favoring your bank-driven restructuring approach.
Christoph and I tend to be aligned, but if I may, there is a very interesting experience which hasn't been looked at sufficiently, I think, which is, it stems from the insolvency of the banking system of Ireland. They created NAMA, which is the public authority which was created to buy the loans from the failed banks. And this massive bad bank public was actually used as some sort of massive restructuring weapon, because they held the loans of the banks, and they decided which ones actually they would try to recover from, which ones they would just sell, which ones they would just write down. So they concentrated the debt and became a massive
asset management company, an asset management company.
Sort of, it was a massive one, but obviously it was done with the view to rescuing the banks. It was never the intention of the government to become, the decider of who is viable and who isn't. But I think we should look more at that type of experience. I'm not saying we should go towards that, because it was obviously exceptional. But it is very often the case that banks have the best information and the expertise to make a decision as to whether the debtor is actually viable or not. And following up on Christoph's remarks, insolvency law, the insolvency system, is basically about separating those that can be rescued and those that can't. And those that can be rescued are those that are not economically distressed, they're financially distressed, and that they have a going concern value. And sorry for saying obvious things. And how we rescue the business doesn't matter. It doesn't matter if we do it by means of a plan or we do it by means of a sale of the business as a going concern. That's just an instrument. That doesn't matter. What matters is that we actually rescue viable businesses and we liquidate quickly without spending money or time of our courts on unviable businesses. And of course, this is very easy to say and very difficult to do. That's why I say that if you want to really do this, you need to act on 4 fronts. You need, first of all, to act on the regulatory side of banks. I can't stress that enough. Second, you need to act on the legislative side and ensure that there is an improvement in financial information by businesses, especially smaller businesses. The quality of the information is absolutely key, and this is one of the problems we always see in less developed jurisdictions, because if there's no good financial information, there is a flawed decision-making process all throughout. Third, we are at the time when we need to get rid of much of the corruption and the problems that exist in real life practice, not only in developing countries, also in fully developed countries, in insolvency cases, and do it through technology. We need to upgrade technology systems, and that can be really a game changer, I'm pretty sure, in the midterm. And finally, we need to avoid procedural privileges, please. Let's stop allowing the public claims from being away from the solutions, because if you do that, especially with the smaller debtors, much of their debt is public. If you just leave the public administration outside the proceeding and give them a priority, not a priority in the waterfall, but a priority procedurally because they can't be affected by the plan, then you're just creating a system that's good for nothing. Why would I try to reschedule or restructure my debt when my main creditor is not involved?
And also an inefficient public service, because basically what is the incentive of be efficient and collect on time if basically I will be the first one to be paid and everything.
Right. So sorry,
no, Ignacio, no. I cannot be happier with your intervention, because basically you have highlighted what basically I think are key aspects, which is expediency, data transparency, avoid procedural privileges and corruption. So basically, the only thing that basically linked to expediency, and I don't know whether we can subsum both together in one category, is basically the simplification of the process, and also it's avoiding unnecessarily overburdening courts, because that will have a direct impact on issues of expediency, another of the issues that you mentioned. And I think that basically definitely upgrading the technology will definitely favor that. Andres, you are next, and basically you are making my task very simple because you are fighting each other to intervene. So basically I can just sit still. Andres, you are up.
Thanks, Rodrigo. No, a couple of reactions. I mean, I first of all, I was listening to everyone and nodding, because I think it's hard not to, but I have a couple of reactions on a couple of things. So first of all, simplification of the process. Is it the silver bullet? I am not so sure. I mean, I think we all talk about simplification of the process, but what it means in certain countries doesn't necessarily mean the same in others. I think the institutional setup required to simplify properly a process and to ensure that there are no violations of rights is sometimes more sophisticated than what most of the countries have. So it may be the silver bullet simplification of the process, but how to do it is not the same in all countries, no, and in all jurisdictions. I think it depends heavily on the degree of specialization, which leads me to the same comment on the hybrid or prepax, in fact, that Catherine was mentioning. Catherine emphasized about prepax, and I couldn't agree more. I think, I mean, I come from precisely, I started practicing law in 2001, right? In 2000, but 2001 I joined my law firm in Argentina, which was exactly at the beginning of a massive crisis, no? We changed the law in 2002. We introduced, or better said, strengthen what we call the APE, Acuerdo Preventivo Extrajudicial, which is the PRIPAC al Argentinian. Were they useful? Absolutely. Now, were they useful for what? To restructure very, very large companies, not small companies, only very large companies that were able to afford paying really massive fees in restructuring, and only those that were able to pay the highest capacity professionals, right? So PRIPACs are good, but in my mind, PRIPACs are good when you have the capacity in the private sector to deal with this and do it with relatively minimal court intervention. Now, the problem then begins when it's brought to a court that is not specialized, because then they do try to intervene. Of course, they need to check all the systems that are in the restructuring process, or that's what it's in the judge's typical mindset. No? So that's a kind of a double-edged sword, but something that I wanted to mention. Something that Christoph said totally resonates with me, which is the issue of reallocation of assets in the economy. It's absolutely paramount. I mean, we at the World Bank Group, we sit at the financial sector practice. No? The insolvency work sits with the financial sector practice. The reality is, it is, as you were saying, not particularly desirable that the debtors are the ones making the judgment call on how the company goes. But that is something that brings me back to my practitioner times, which is the biggest problem we had when restructuring companies was not necessarily the viability of a company, which is what we all, as insolvency, in the legal reform process, we say, well, if the company is viable, it should be restructured. If the company is unviable, it should be liquidated, period. Yeah, but nobody mentions trust in the management. And frankly, when I had to litigate, when I was practicing in restructurings, the biggest bottleneck we had was the absolute incapacity of removing the management of the company who had lost the trust of the lenders. And that is something that bankruptcy laws don't make it easy, and particularly don't make it easy in those countries that have a corporate structure that is a family driven, where the corporate governance, separation, management, independent from the shareholders. Yeah, sure. How often do you see it, right? And I'm not only talking about small countries. I'm talking about very large restructurings, but that companies that are family owned, and it's not the same corporate structure that you would see in the US or in the UK from the ones that you would see in civil law countries. So I wanted to mention that as one of the issues that I think is something worth looking into. And I have one more very small point.
Andres, can I interrupt you, because I don't want to lose
Please.
track on this, because basically there's an important aspect here which what you refer with is confidence in the management, which I think it's key. The question is, and here is where I'm provoking you a little bit, because there are two things here. One is, how do you square this with Nacho's reference to corruption? And there are some judicial systems where basically it's slightly more difficult to trust the management, because there are some unpunished deeds. And in addition to that, basically you will have some creditors which are more sophisticated than others. And if you have crashed the company, why shall we let you again in the driving seat? I know that basically this is oversimplistic, but it is what you're saying. I know the importance and I know where you're going, but I think that basically it's not that simple to square this circle.
It's definitely not simple, and I am all about debtor imposition, right? It's nothing that I said contradicts that spirit. Right, so I think we all agree that the best management, the best is that the debtor continues managing the company, because it's a continuity. They know the business is cost effective, etc. No? But particularly in large cases, I'm not talking about micro small cases in this case. I think there needs to be a further refinement in many countries in what it comes to the management removal. Yeah. I don't think I'm contradicting anything that has been said so far. I think for micro small cases, no, I think Nacho articulated it very clearly.
Andres, I think you were just missing that clarification. Sorry if I missed that one, but I thought that was the angle. You had another small comment that I interrupted you. Sorry, Andres.
that is a very, I mean, it's a small comment that to me has a massive impact. In most countries that we are working today, the courts are overloaded with either no asset cases or cases that are insufficient to open the process. I think I'm not a big fan of the solution of simply not opening the process because of the clawback actions. And I know, I mean, I think here the Germans have a lot of experience, and Christoph, maybe you want to comment on that. But I think something needs to be done. So judges don't spend too much time on these cases, and it's happening around the world, and something that keeps the parties safe, particularly the creditors, when there has been misbehavior. But that's the minority of cases, and we should make sure that for the majority of cases, this doesn't even take so much time and space from the courts. And I think that's one of the challenges that many countries have to.
Andre, thank you very much. I would like to strongly highlight what the reference that you made to. I tried to summarize this in a short sentence, but basically I think that one of the key aspects is the institutional and infrastructure support, because basically many of these things cannot reach the finish line because of the lack of infrastructure and institutional. But institutional, I refer to it in a very broad sense, basically the whole system accompanying not just the courts, but ancillary legislation, capacity building, the role of insolvency office holders. So I think that it is, in a broad sense, you need to professionalize the whole system that deals with companies in distress. Catherine, you raise your hand, and then we have Nacho, but I'm also conscious about the time, because basically there are at least two of the panelists that need to leave on the dot. So Catherine, with your intervention, I would like to start shifting towards the last minute, or I mean, do your intervention, but if you can add towards the end of your intervention something on, okay, we have identified that there are some key trends in insolvency, and tell me what's your experience on how we can get this from the drawing board into the actual legislation.
Thank you very much, Rodrigo. Actually, I can stay a little bit longer, so I don't have to leave exactly on the dot of 7. Well, I've been taking a few notes because there's so many ideas. It's hard to respond to all of them, but I just wanted to make a few points. When we talk about the debtor, we talk about creditors, but we all know that creditors, it's not a homogeneous group. Each creditor has its own agenda. There's, of course, the massive division line between secured and unsecured creditors, and then you have preferential creditors. So I think it's worth bearing in mind that of course, what we really need for insolvency laws to work is the concept of majority creditor decision making. And then, of course, you have the issue about secured creditors, because in a number of jurisdictions, secured creditors have been more or less sidelined in the insolvency process. They can't participate. So one of the trends that emerged from when we were looking at insolvency laws across these 40 jurisdictions was that in a lot of the more traditional jurisdictions, creditors who are secured would have to relinquish their security to participate, which of course no creditor would do if it had the choice. So I think it's worth thinking around this, the dynamics, the creditor dynamics, and in a lot of countries where we work, there's still definitely, and I think I saw Milo Stevanovic made this comment about enforcement, because in a number of countries, creditors, what do? They rush to enforce because they don't trust in the perhaps the general body of creditors to come up with the best enlightened solution. They simply don't trust each other, which goes back to the point that Andres made. I think Ignacio mentioned the role of technology and digitalization in getting rid of corruption, bringing clarity. Yes, I definitely think technology has a significant role to play, but it needs to be accompanied by regulation and a willing regulator, and for governments to invest in regulation, maybe setting up an agency or a body that looks after insolvency practitioners, which is actually, I think that's fundamental, because what we see now, I'm working on a big project at the moment with an insolvency regulator, is there's so much that you can do with technology to monitor, to gather data, to really understand, but it depends on how ambitious the regulator is and the authorities are, and how transparent they want to be. And going back to this aspect of the debtor choosing whether or not to be saved, or choose, making the decision to initiate early preventive proceedings, I think it's very difficult. It's sometimes very difficult for an independent party to sort of decide which debtors should be saved and which shouldn't. So I think it's easier to leave it to the debtor itself. And then finally, just another response. We're talking about insolvency as a sort of cleanup mechanism for the economy. Fully agree. And then going back to the idea of SMEs, I mean, I think there really needs to be somehow also a cost benefit analysis, because going through any kind of procedure is expensive, and there has to be something that's really worth saving when the business is in distress. Or going back to Andres's comment, where you have a lot of businesses that are have no assets or very limited assets. In terms of, I think you had a question, just to transition, Rodrigo, to the next part, which is about what we should do.
The next and the last, I think that we should be bringing this to an end soon. But Catherine, I wanted to know, we have identified a few trends that or good practices, and the question would be, I think that all 5 of us here on the panel have been involved in one way or another in legislative reform. So I would like to know how we can translate this into legislation. What is a little bit about the most effective manner, if there is one, to action on these points and try to translate them into actual legislation for the enhancement of insolvency law in different jurisdictions?
Well, just to be brief, I think that we've never had a better moment in terms of getting legislators time as now with the crisis. This is really, I think, an opportunity for organizations like the EBRD, the World Bank, and others to get attention on what has sometimes not been the most fashionable subject, although I find it personally very interesting. So I think it's a good moment for policy dialogue, and also for making the case for a bit of a mental shift around insolvency. So it's not just liquidation and cleanup, but it actually offers a range of possibilities, and I think it's not just about legislation. I almost don't know, as a working in the area of policy, where to begin, really, because I think there's so much that needs to be done within the court system and within the profession of insolvency
and society in general. I think
society.
It goes beyond just the judiciary.
Yeah.
Nacho, you need to be making an exit relatively soon. So I know that you might make a quick escape at some point. So let me start by thanking you for making the effort, and I will give you the floor to you, please, Ignacio.
Thanks a lot for this. Has been fun. Just very quickly, I would like to pick up part of what Catherine just said, especially in the light of the comment of the colleague in the chat. Sorry, I forgot his name, and I can't see it anymore. Milo, right? enforcement over security rights when a debtor is insolvent or near insolvent may happen in some countries as a matter of a rule without even going into the business case of the debtor when security right falls over fixed assets, immovable property. That is bad banking. I'm sorry. If you only lend against immovable property, that's bad banking, and it's a regulation problem. So we can't really analyze properly an insolvency system if we don't look at these things. So it's the structure of the lending that really matters and influences the behavior of banks exposed. So that's to begin with. A bank, good banking says you have to lend against a business case, not against the amount of real property that the debtor can give you, especially because most small debtors and medium size won't have any real property to give you. So access to credit becomes impossible. If, however, the assets that are subject to security rights are movable assets or are a pledge of shares that aligns the interest of the debtor, if the debtor is viable with that of the bank, and enforcement won't happen. At least that's what I've seen in many countries. Banks enforce when they have to, but not as a matter of a first thing. They only do that when there's real estate and they don't have an adequate supervisor above their heads. So banks in relatively developed places don't enforce just as a matter of automatic reaction. And if they do, that's bad banking. And that has to be supervised and
Ignacio,
regulated.
clearly the business of banks is lending, not owning property.
Not owning property. So, yeah. So I think I wanted just to make clear that that's not the way to go. And you have to look back and look at the banking system if you want to solve the problem. And my last remark concerned no asset cases, which Andres very well identified as the key in many countries, in most countries, I'd say. The German system of which is retreating in a way of not opening a very large portion of the petitions works fine, I guess, in Germany because the honesty of the is very high. The level of honesty is very high, and because the incentives that such a measure automatically creates in a market are contained in Germany. So, but in countries with a lower level of honesty in the market, it's a terrible solution. It's a terrible solution to begin with because it's a denial of insolvency law from outright denial of insolvency law. You deny the possibility of actually doing things well. And second, and most importantly, it creates the perverse incentive of the worse, the better. Because obviously, if I have a few assets, I'm going to be subject to insolvency law and to scrutiny. If I have no assets, then nothing will happen. I will just, go home happy and start over. So that might work in Germany, but that's not a solution in most countries, I would think. So I think we need to provide a solution for this. Yeah?
Ignacio, I'm laughing. I'm laughing because it reminds me on a country mission that I did with Andres. Andres is laughing already. I was hesitant whether to mention him or not, but he started laughing before I finished the sentence. So basically, either there were no assets and insolvency holders were not willing to take the case because basically they will not be remunerated because remuneration was linked to the value of the assets and the recovery. Mm-hmm. And then the other one was on bad banking because basically banks were only lending over 200% collateral. So
over collateralization is the other problem.
Over collateralization.
That's the other problem. Yeah. But that's again regulation and it's again supervision. It's the same thing.
Ignacio, thank you very much. We will continue 5 minutes because I think that Andres has his hand up. Christoph put his hand up and I now down. But if you need to exit,
can I just insert just very briefly to what Catherine said? She
Ignacio, if you need to leave, make an exit whenever. Sorry, Christoph.
Okay, thank you all. Thank you.
Bye, Nacho. No, Catherine, you said it's now the best time because we are in a crisis. I mean, that is exactly the point. Yes, we are in a crisis, but I don't see the crisis. I mean, the figures of insolvency cases are, wherever I look, they are pretty low. And it's hard to explain. I mean, this is what that was the beginning of my deliberations about we are again in a phase in which we are stigmatizing insolvency and we are pushing it to a place It's not done. It's not done. And we have, and this is, insofar not a crisis, it's an ideal time for evading insolvencies. We all don't know where are the insolvencies. We must have an enormous increasing amount of zombies. Where the hell are they? So that is my issue.
Christoph, in one of the previous seminars, the term that they used was a Spanish term that basically companies are dopadas. That means that they're under the influence of drugs. They are kind of being kept dormant.
Yeah, right.
Yeah.
Right.
And I think just to interject there that there are some countries where we work where banks have been under a lot of pressure to continue supporting businesses. So I think really my sense is the can has been kicked down the road, to use an English expression, but still the insolvencies aren't coming, and that is it is something that I think about and wonder why.
Catherine, the question is whether there are insolvencies or restructurings, but one way or the other, I agree with you that basically they will be coming. Andres, the floor is yours.
Again, a couple of quick reactions. I totally agree. There is a zombification, which is a word that I heard the other day, and I very much liked. Now I use it whenever I can. But yes, I mean, there is clearly an increase in the amount of debt, and it needs to be resolved one way or another. So it either will translate into a larger number of cases of bankruptcy cases, or in a larger number of as Milo commented on, debt enforcements, right? Now, that moving on to the second point and addressing the question or the comment that my friend Milo posed in the chat. I mean, I agree with what Nacho said. Lending, I mean, purely based on properties, but lending. But the reality is I haven't seen that happen so often. I mean, for banks, enforcing on collateral is typically the last resort. Now, what changes is in fact something different, which is the negotiation, the restructuring negotiation takes place at the shadow of the enforcement of how strong the enforcement laws are. No? So if the bank knows that they can repossess, bank, and I'm using as a generic for creditor or lender, no? A secured creditor in this case, knows that they can repossess the collateral or sell the collateral while the insolvency is ongoing and in a relatively short period of time, of course, then the negotiation, the negotiation power of that creditor will be much higher, much stronger. No? And yes, there is obviously a tension of that. Between how so it's a matter of policy, no? But I completely agree that the right policy is to try to first of all have some degree of automatic stay, which is not as universal as one may think. So that was, and that leads me to just one more comment I think that I have. Sorry, two more comments. One of them was picking something that I forgot to mention, tax claims. Yes, I totally agree with Nacho. Now that he left, I can say it. It definitely abolish the privilege, the priority of tax authorities is critical. I had a very funny anecdote in Central America, in one of the countries that we did not work together. So this is a different one, that I met with the tax authority and I basically mentioned this as, I mean, together with the champion, who was the deputy minister of economy of that particular. Oh, was it with you? No, it may have been with you.
Andres, we were surrounded by 15 tax officials.
I think so. Yes, I think so. Yeah.
I thought that that would be how my life will end.
And we survived that meeting. Because the response that the tax administration guy gave was over my dead body, right?
They have a very different approach.
So yeah, I mean, in general, I think that's the perception of a tax authority. Now, whenever I have been asking tax authorities if they keep track on how much they recover in actual insolvency processes, the answer is universally, they have no idea. They have no idea. So they like the priority, but they don't know how much they are collecting in insolvency processes. I am sure that in more sophisticated countries, this is probably not the case, and they may be keeping track. I can tell you in most developing jurisdictions and not so developing, this is the case. There is no account of that. The other point very much related to this is the incredible reluctance of humans working in tax authority. Let's forget about the tax authority in general, to sign any haircut, any debt, any sort of, even debt rescheduling. So let's not even talk about haircuts of principal. That's definitely not going to happen. But even the reschedulings they are reluctant. They are afraid that they will be put in jail, basically. And I mean, Greece has done a lot of different things to try to solve this. First, they put it in the law, it didn't work, and now they are creating some sort of algorithm. I think it came into force at the beginning of this year. I have no idea how that's working, but I think countries are trying to come up with some creative mechanisms to put tax authorities out of this, this poor thing. And yes, the final comment is, you ask Rodrigo in a forward-looking question, how do we translate this into legislation? And I think so far the biggest problem is the copy-paste. That's the problem. I mean, but the biggest problem of legislators, in particular in developing countries, is, oh, look at what Germany did. Let's copy it. Let's put it in our legislation. I mean, if Germany did it, it must be okay. Yeah, sure. But again, you know, I've seen a few Balkan countries copy-paste German legislation, and it's, you know, it's not working exactly the same.
You need institutional
Sometimes
support,
they don't even
infrastructure, yeah, capacity building.
So
Yeah.
it's a massive problem. So I think any legal reform project needs to begin with a proper assessment of the not only the legal system of that country, but also of the institutional capacity of that country. Without that, nobody should touch the law. That's the point. Sorry.
Andres, thank you very much. And I will do the last round, 30 seconds each before we bring this to an end. And I have 2 hands up, and basically, guys, you are all signed up for be regular presenters in my webinars, because basically my job is very easy. Catherine, you raise your hand first.
No, thank you, Rodrigo. It was just something that occurred to me when I was listening to Andres, which is that what is really important also in a reform process is that the public officials also listen to the private sector and what's going on in the private sector. And what we see sometimes is that the reforms are carried out, but with very little consultation. So that's really, I think, it's something that I think is very important whenever EBRD is involved, that we also try and act as a kind of bridge to the private sector to make sure that there is proper consultation, and this isn't just a copy paste of another country's legislation, and that that policymakers are also aware of some of the issues and bottlenecks are. So it's properly tailored to the country.
Thank you, Catherine.
A quick word to what Andres said. I mean, it's a wonderful example that you brought about these human beings, not the tax authority, but the human beings, which are moreover civil servants. In this context, the Greek only recently, I think in this year, rediscovered the wisdom of ancient Roman law. They made explicitly the decision, when you are silent, it is deemed to be consent, qui tacet consentire videtur. So it is exactly this kind of transformation into legislative reaction to this personal attitude of a certain category of people which are bothering you in insolvency.
Christoph, thank you very much. Andres, do you have anything else to add? No. Okay, I will.
Thank you, Rodrigo. Thank you.
Yeah,
thank Catherine,
thank you
Christoph,
very
and
much.
Nacho for an absolutely fantastic discussion. I am beginning to find that I enjoy more these panels that are unscripted than the ones that require the 60 slides that I was planning to present today.
Before we bring this to a close, I will try to summarize, because it has been, it's almost impossible to summarize what we discussed today, because it was a roller coaster ride on pretty much everything what is happening today. And with the caveat that this might sound oversimplistic, I think that there's a general agreement on the importance of data transparency, the important role of hybrid procedures, as long as we know what hybrid really means, the importance of debtor in possession and making sure that there's a chance or a second opportunity. Then I think that one of the biggest, if not the biggest trend at the moment is on SMEs. And when we talk about SMEs, between parentheses, I would like to also emphasize it's not just SMEs, but also micro and nano. That's subject to each jurisdiction and how they define and also is linked to their business structure. And then finally, I would like to highlight a couple of issues that has to do with expediency, procedural privileges, and also the need to have proper institutional and infrastructure support, and institutional in a wider understanding, not just the court, but also the professional stakeholders, capacity building, the proper support. With Ignacio, we were even talking about bank supervisors and bank regulators. So basically looking at insolvency in the wider context. With that, unless I'm corrected, I would like to thank very much our panelists. You encapsulated perfectly what Professor Juana Pulgar and myself wanted to do with this webinar, which is have this informal and dynamic conversation among experts. And I think that today it worked pretty well. So thank you very much to the panelists, and I look forward to seeing you soon again, either at being at risk in a tax office in Central America or in another event. Thank you very much, and look forward to seeing you again soon.
Bye, everyone.
Thank you. Thank you, everyone.
Thank you.
Bye-bye.
Bye. Thank you.